Welcome. I am Adeline Frew, the Director of Appointments with the Northern Ireland Judicial Appointments Commission. NIJAC is currently recruiting 42 medical members and 14 disability qualified members of the Appeals Tribunal. The purpose of our session is to help inform potential applicants about the work and the rewards of the Tribunal. I'm delighted to be joined by Mr John Duffy, the President of the Appeals Tribunal. John is an experienced solicitor and has been President since 2015, having already had a very successful career in private practice and serving as a legal member on the Appeals, Valuation and Criminal Injury Tribunals. Dr. Ian Ryans also joins us. Ian is a GP who has successfully combined a career as a GP partner and serving as a medical member on tribunals. Lastly, and by no means least, is Mary Halferty. Mary is a disability qualified member, which she has enjoyed combining with her physiotherapy practice. John, can I begin by asking you to tell us about yourself and about the role of the tribunal?
Thank you very much indeed, Adeline, for that. My name is John Duffy. I'm the President of the Appeal Tribunals for Northern Ireland and have been in that role since 2015. I have overall responsibility for the judicial functioning of all appeal tribunals throughout Northern Ireland. This includes an obligation to provide induction and ongoing refresher training to all members of the tribunal. The Appeal Tribunal is part of the overall administration of social security benefits. It is a judicial body and it is designed to provide legal redress against the decisions of officials from the Department for Communities, previously known as the Department for Social Development. It's important to bear in mind that the assessment and payment of social security benefits is an essential and significant part of economic life in Northern Ireland. And at any one time, upwards of 300,000 people of working age may be in receipt of a key benefit at any time. So the Appeal Tribunal hears appeals in relation to all social security benefits, plus tax credits, housing benefit, child support, and the recovery of social security benefits, hospital and ambulance charges from personal injury compensation. The Tribunal considers upwards of 10,000 appeals annually. So the procedure is that where an official of the Department for Communities makes a decision in relation to benefit and a claimant disputes that decision, there is then a right of appeal to the tribunal. The decision of the tribunal is final and is binding on the parties to the appeal, apart from if there is a point of law. But if an appeal succeeds, the department must make the appropriate payment based on the tribunal's decision. The tribunal is chaired by a legally qualified member, and he or she has responsibility for the conduct of the hearing and the procedure of the tribunal, and the legally qualified member takes a note of the evidence at every hearing. Up to 4 appeals may be listed during each half-day session. A presenting officer from the department may be in attendance at some hearings, but the department often relies solely on the written submission prepared by it for the purposes of the appeal. Appellants may opt for an oral hearing or to have their appeal determined on the basis of the appeal papers only. They are encouraged to attend if at all possible. The appeal is considered in as much detail as is possible, taking into account all of the evidence.
There are different types of judicial members.
There are indeed, Adeline. The members are divided into 4 different categories: legally qualified members, medically qualified members, disability qualified members, and financially qualified members. And we have more than 250 members in total. So it's a large tribunal and a very busy tribunal. The regulations prescribe what category of members will hear an appeal and the various powers of the members. In essence, medical members sit in appeals where issues of disability arise. The relevant benefits are disability living allowance, attendance allowance, personal independence payment, employment and support allowance, and industrial injury disablement benefit. Where an appeal relates to employment and support allowance, a legally qualified member sits with a medically qualified member. Where the appeal relates to disability living allowance, attendance allowance, or personal independence payment, the members of the tribunal are a legally qualified member, a medically qualified member, and a disability qualified member. This latter category may include occupational or physiotherapists, nurses, health visitors, and people whose work and/or their own personal experience makes them conversant with the needs of disabled people. And we also have a number of disabled members and carers in this latter category. The current schemes from NIJAC are for the recruitment of medically qualified members and disability qualified members.
And what are the characteristics of an appeal tribunal?
First thing to bear in mind in relation to tribunals is that to a large extent, they are the first experience that members of the public, many members of the public have of our judicial system. So a positive or negative experience at a tribunal can colour the perception that a member of the public has in relation to the justice system generally. And that's an extremely important thing to bear in mind. There have been two seminal reports over the years which attempt to clarify the characteristics of tribunals. The Franks report as far back as 1957 and the Leggett report in 2001. Both authors agreed that tribunals can be defined in the following way. Firstly, they're independent. Secondly, they're expert. Thirdly, they're informal, as the rules of evidence don't apply to our hearings in the way that they apply to court proceedings. Fourthly, they're accessible. And fifthly, they're cheap. I'd like to explain what I mean by that. They're independent in the sense that they are judicially independent. This is reflected in the oath of office that decisions will be made without fear or favour, affection or ill will. That oath of office will be taken by any successful members for both of these competitions. It is therefore essential to respect all appellants regardless of your view of their social standing, their sexual orientation, their race, their creed, or their political opinion. Tribunals are expert in the sense that the ordinary courts depend on expert medical evidence when dealing with medical issues. It is very rare for a court to sit with a medical expert or an assessor. The courts may receive other forms of expert evidence, for example, from engineers, architects, or accountants, but tribunals, on the other hand, have expert members. And these include medical members and the different categories of disability qualified members. Tribunals are informal to the extent that the detailed rules of evidence which apply in court proceedings do not apply to the same extent to our tribunals. Tribunals are accessible to the extent that hearings take place as geographically close to appellant's home, thus creating a local service insofar as that's at all possible throughout the province. Accessibility also means procedural accessibility through informality. This enables an appellant to understand what the tribunal is doing so that he or she can contribute to the hearing. Finally, tribunals are cheap to the extent that legal aid is not available at our tribunal hearings, and in practice, very few lawyers appear, although lawyers are very welcome to attend at our hearings. In addition, there's considerable reliance on documentary evidence, including expert evidence and other evidence provided by the department. The average cost of a tribunal hearing in Northern Ireland is around about £300, excluding the cost of preparation by the department. So tribunal costs are therefore very modest indeed when compared to the cost of court litigation.
And why do people apply to be a medical or disability member?
This work is extremely challenging. It's very stimulating. It's very interesting, and it is highly rewarding. We have an excellent, hard-working membership, and I cannot commend enough the work to all potential applicants for these really exciting opportunities, because opportunities of this nature do not come along very often within our tribunal.
Thank you very much, John. Ian, if I can hand over to you. Please, can you tell us something about your background and why you had an interest in the work of the Appeals Tribunal?
Thanks very much, Adeline. I'm Ian Ryans, I'm a GP, and I started working in the Tribunal Service in 1994 or thereabouts, so it was quite some time ago, and it was early in my GP career. I was doing locum GP work at that time, and I found the role particularly attractive because of its flexibility, if you like, and it's the ability to fit it around other aspects of my medical work. Portfolio careers are becoming more and more looked for within the medical profession, both as GPs and in other areas of medical expertise. And this sort of role was ideal for me at that stage. And as I developed through my career, became a GP partner, I was able to adjust the tribunal work in order to suit the type of work I was doing at different parts of my career. And I was able to develop other areas of portfolio interest in musculoskeletal care and things like that, along with tribunal work. And then, as well as that, as my experience has increased in this tribunal, I've been able to develop other medical legal roles and sit on other tribunals, such as the Criminal Injury Tribunal and the Mental Health Tribunal, for example. So all of those opportunities really sparked my interest in this whole area.
Thank you. And what is involved?
Well, as John has said, the medical members will sit on with two other members in personal dependence payment, disability living allowance and attendance allowance cases, and with one other member, a legal member in ESA, employment support allowance and universal credit cases. So it does involve assessing these situations. These benefits are assessed by examining healthcare professionals with a scoring system, trying to assess a level of disability associated with their various conditions. So assessing that is part of the role of the tribunal.
And for you, what preparation is involved?
Well, the preparation is very important and is actually a very stimulating and interesting part of the whole process. You'll receive your papers well ahead of time, a number of weeks before the tribunal sits. And the papers consist of a submission from the department, as well as the applicant's claim form for the benefit, the examination information from the examining healthcare professional, and as well as that, any other evidence that the appellant has brought together. And that might look like medical records, hospital letters, submissions from the representatives, things like that. So a good bit of the time in preparation is in reading this information, trying to assimilate it, take notes on what the important aspects of it are, and trying to come to some sort of preliminary view or assessment of how the case is going to run, particularly in terms of trying to find the medical issues that might come up in the case.
Thank you. And on the day, the actual day of the hearing?
Well, on the day, you're sitting with your colleagues, as I've indicated, and there'll be an initial discussion with your colleagues about the case, and that will, from your perspective as a medical member, involve advising the panel on the medical aspects of the case. And that might be trying to explain diagnoses, explain examination findings, and how those things will relate to disability. Also, there are often scoring scales, MRC breathlessness scales, exercise tests, etc. in the records. And you might want to explain how that again relates to likely disability. You may be discussing medication side effects, the relevance of different medications to the claimed level of disability of the claimant. So that sort of initial discussion can be very helpful in trying to clarify some of the medical issues from a medical perspective. Obviously, the legal member will clarify issues from a legal perspective, and the disability qualified member from their perspective as well. Then most of the cases, as John has said, are oral. So a small number may be determined on the papers alone, but most you will be taking oral evidence from the appellant. And that process is a questioning process where you're able to question the appellant about how their medical conditions affect them on a day-to-day basis, what sort of investigations they've had, and try to get a sense on the day from the appellant of how they're affected by their condition. And that questioning process then brings, all the members will be involved in that questioning process, not just the medical member. And then you're able to bring that evidence together to try to make some sort of assessment of the credibility of the witness, of the appellant, and how credible they appear to be. And also then you start to weigh up the oral evidence against the written evidence you've already read and try to come to a decision. And when the appellant is left, then the tribunal will discuss further and then come to a decision on the day.
Thank you. And what are the advantages, the attractions of this work?
Well, as I've said before, portfolio careers and variety in work is really becoming increasingly important, particularly to young GPs and other medical professionals. And I think this is an ideal situation to develop a flexible role in your medical career. The tribunal work can fit around other medical roles very well and can change as your career progresses. I think it allows you to develop a number of skills which are really transferable between the different roles in medical and judicial areas. For example, an understanding of the benefit system is really helpful when dealing with your patients on a day-to-day basis. Also, those skills in questioning and weighing evidence and assessing credibility, and those communication skills that you can hone help you to have another, if you like, string to your bow in terms of your communication skills. And then I think another important aspect is engaging with other professions outside that medical world. I think engaging with legal professionals and other professionals really gives you an experience that is helpful in your career development, and also gives you another perspective, if you like, in terms of in the wider sense. Also, the experience allows you to develop a medical legal aspect to your career progression, and as you develop, you can develop other roles, as I've indicated previously. So I would highly recommend the role to prospective medical professionals who wish to apply. Certainly has been a really positive role in my career.
Ian, thank you so much. Mary, as a disability qualified member, may I turn to you? Please tell us something of your background.
Hello, Adeline. Thank you very much. I qualified as a physiotherapist and I worked full-time in the National Health Service. I started doing the DLA appeals from its inception in 1992 alongside the attendance allowance appeals. And then more recently, when the PIPS appeals came on board, as the personal independence payment came on board in 2016, I did those appeals. And I was able to combine the role of a full-time clinician while doing sessional work for the tribunal service.
Very good. And tell me about your role on the tribunal.
Okay, as I stated before, I sit as the disability qualified member, and it's a 3-person panel. And the chair sit alongside the chairperson, who is legally qualified, and a medical member who may be a GP or come from a consultancy background. And together we make up the independent tribunal, which is independent from the department who made the decision and the claimant that's appealing that decision. I worked in a number of different clinical areas in my career, and I hope all that background experience is helpful in knowing how a claimant's presenting condition impairs their functional ability.
Thank you. And how do you prepare for a sitting?
I think as stated by the rest of the members, we receive a bundle of papers which is sent from the Tribunal Appeal Service roughly about 3 weeks beforehand. And that contains the claimant's submission papers, the disability assessment report, the departmental decision for disallowing in all or part of the appeal, and that's based on submitted evidence. And also GP and consultant notes may be included in that as well. We have to consider 10 daily living activities and 2 mobility activities, in the personal independence payment, and that's on a scoring system. And as for DLA, we have to consider day and night issues as well as mobility issues. And for attendance allowance, we have to consider day and night issues, and there's no mobility in the attendance allowance. And those latter two aren't points based. So as Dr. Ryan says, we have to read all the papers beforehand in your own time, and we make notes and possible questions that we're going to ask on the day of the tribunal. And normally in PIPs and DLA and attendance allowance, there's normally 3 sittings heard in one session.
And again, if we can tell us something about your experience of what happens actually at the hearings.
Okay, on the day of the hearing, the panel meets beforehand to discuss all the cases prior to the claimant coming into the room, and that is the doctor giving his evidence on maybe medication and any investigations that the claimant may have had. It may be an oral case where the claimant arrives in person, or it may be a paper case where it's heard without the claimant being without the claimant not being present. And the claimant is asked questions relating to their functional ability on all the descriptors, and that gives us more clarity and detail, which may not be evident in the claim form or the medical evidence or the assessments, and that helps us greatly to make a decision. The claimant may be assisted in their appeal by a representative who may be present or who have sent in prior to the hearing areas for the panel to focus on. And a presenting officer may be present at the tribunal. They represent the department, but they may or may not be present. And all 3 members try and reach a decision on the day with all the evidence before us. That's the oral evidence from the claimant, all the medical evidence, and the written submission evidence on the client's claim form. And we hope to arrive at a fair decision.
Thank you. And would you recommend the role to others?
Yes, it's a very attractive role in that it allows great flexibility as regards the number of sessions that you wish to take part in. And I would encourage people who have experience in dealing with the needs of people with a disability, either on a professional or a voluntary basis, or as a disabled person themselves. And it enables you to bring your wealth of clinical experience. If you're a carer, what care you give to a disabled person, or the caring needs if you are a disabled person, and interviewing skills. And it's great to be part of a judicial making process. And would highly recommend work in this area, as it may be a role that you've never ever considered for yourself. Okay, thank you, Adeline.
Thank you, Mary. That was really, really helpful. I would like to take just a little time to highlight the materials and assistance that's available for potential applicants on the NIJAC website. There are nature of the role documents which give additional information to that which is held on a job description. And there are judicial profiles on other members of the Appeals Tribunal, and also guidance on applying for fee-paid judicial offices. There are also 2 members of the Appeals Tribunal who are available to speak to on a confidential basis, who take no part in the assessment process, but who you can speak to about the nature of the work and whether or not you think it would be suitable for you. All this is also held in the applicant information booklet, again on the NIJAC website. And also in the applicant information booklet, you'll find our consideration regarding making sure that the recruitment process is as COVID secure as possible. Applications for the medical member close at 12 noon on Monday, the 14th of June, and for the disability qualified member at 12 noon on Monday, the 21st of June. Good luck, one and all. Finally, I would like to hand over to John for a few final words.
Adeline, thank you very much for all your help in relation to this, both in relation to the general applications, setting up the webinar, and all your expertise throughout to enable Ian, Mary and myself to take part in this webinar. I repeat what Adeline has said in relation to the documents that are available. If you go to the website, you will see a judicial profile in relation to myself, and you will also see a judicial profile in relation to our medical members and our disability qualified members, and I would commend all of those to you. A couple of very important things that that Ian and Mary mentioned in their presentations, and you may not have thought about these. I have noticed it over the years, and Ian has mentioned it as well, that work of this nature brings you out of your own little silo. As a doctor, you're used to dealing with doctors all the time. As a physiotherapist, you're used to dealing with professional colleagues all the time. And as a lawyer, we're used to dealing with lawyers all the time. Work of this nature brings you in contact with a different team, and you develop a rapport with all those different people. I think that's best evidenced by the fact that we have a substantial number of our members, legal, disability, medical, financial, who have been with our tribunal for years, who continue to stay with the tribunal and who love it. I would encourage people who are considering doing so to put in their applications, because I can guarantee you that this is challenging, rewarding, and stimulating work. And I repeat what Adeline said, which is to wish you all the very best of luck with your application. Thank you very much indeed.
Thank you, John.